Welcome to your virtual presentation for Wellness Facility Management. This is WL 485. This is your instructor, Dr. Chad Kish, and you are in Module 13. We are Chapter 16, Legal Responsibilities. We're in Unit 4, Facility Administration. And once again, this is virtual presentation for Tuesday, November 28th. We're replacing our face-to-face classroom presentation with this audio-enhanced PowerPoint presentation. So for this Module 13 virtual lecture, there's no class meeting on Tuesday, November 28, 2023. This is the Module 13 PowerPoint. It's audio enabled. Obviously you found it. It's linked in the Module 13 virtual lecture page as well as the information page. What you need to do is read the slides just like you would in a classroom and listen to the audio, and you should take notes as you go. And I'll explain what you need to do when you take notes on the next slide. You should do that in your journal activity for Module 13 because you will turn it in by 8 p.m. on November 28th. So there's two options on how to view and listen to this PowerPoint. When you open the PowerPoint, you can click on Slideshow in the top banner at the top. Click from the beginning or from current slide, wherever you want to start. And the presentation will play just like a movie. So there's an audio file basically embedded in each slide. And when the audio file gets done, when I get done talking like I would in a classroom presentation, it will skip to the next slide. It'll automatically advance for you and play the next video file. So it'll be like a movie. You'll have to actually pause it to be able to stop it if you need to at any particular time, and then you can always go back and hit play from current slide. Or if you want to do it on your own and advance on your own, you can just open the PowerPoint like you would. You can go slide to slide, advance it yourself, click on each slide with an arrow, or go scroll down with your ribbon on the left side and click to the next slide. There's going to be a little gray, what looks like a speaker. You'll click on that and it'll give you another icon, and the icon's going to have a little arrow. You'll click on the arrow and it'll play the audio for that specific slide. And when you get done, it'll stop. You'll have to go to the next slide, or you can replay the audio on that slide. And you'll have to do it on each one, so you'll have to click on that gray speaker and the arrow for each slide as you go. So how do you take notes? You'll take notes and basically turn them in. They're going to be due on the day that the virtual lecture would be done at 8 o'clock, so you won't have to have them done during the actual class time. You'll have all day to do them. So they'll be done in a journal activity. So you'll have a journal activity for Module 13 that'll be due today, Tuesday, November 28th at 8 p.m. And you'll have another one that'll be due on the 14th. So here's the assignment information. You're going to listen to the virtual lecture that is embedded into the PowerPoint, like I explained on the last slide. You're going to complete this journal activity for Module 13 by providing detailed, college-level, well-written, and factually correct answers to the questions based on the presentation. The textbook readings will help you out, but it's basically going to be based on the presentation. Number your answers. So I have numbers here. You're going to define following terms in one sentence. So you'll have them 1 through 7 under terms, and then you're going to provide detailed answers for following questions. You'll have questions 1 through 10. And some of them are just going to be explain or list, or it's going to say give me something in 1 to 2 sentences so on your questions. So you're going to consider the activity like the process of taking notes. The terms are in order 1 through 7, and the questions are in order. Now, the questions and terms might overlap because there might be a question and a term, whatever the case. But the terms are going to follow in kind of an order in the presentation, and the questions are going to follow as well. So they're not going to bounce all over the place. I try to make it easy for you. So basically, you're going to take notes along the way, and you should see these things. Some of the things might be on the slides, and some of the things are only probably going to be in the audio. So if you only just scroll through the slides, you're not going to find all this information. You're going to have to actually listen to the audio and listen to the whole presentation to find out all of this information. So take notes. What I would do if I were you, I would copy and paste the terms and the questions from either this slide. That might be hard to do. You can go into Canvas, open Journal Activity Module 13. You can either have 2 screens open and complete it right in Canvas, or you can copy and paste the terms and questions out of Canvas into a Word document or whatever word processing you use if you don't use Microsoft, and open that document then and take your notes in that document, save that document, and then you will just turn that in basically as your notes. You should be able to do all this right as you listen and read this presentation. It basically just provides the integrity that you listen to this virtual lecture. Nothing's tricky, it's all pretty straightforward. So it's basically just going to be taking your notes off of the virtual lecture. All these things are going to be right there laid out for you. So we're in Unit 4, Facility Administration. We did Marketing and Sales for Chapter 14 and Financing and Budgeting for Chapter 15 before we left for Thanksgiving break. Today we're going to talk about legal issues and responsibilities, things like risk management and a lot of different legal terms, and how we need to pay attention to all the different governmental laws and regulations and things, and how we will apply that as a facility manager. And then next time we'll talk about security and emergency management, and then event management and how that applies to a facility manager. So we're in Chapter 16 today. We're going to use that background and foundation from Chapter 16, and I'll fill in some other information from my background and experience managing a variety of different facilities. We're going to cover information about legal concerns and risk management that you would use in the realm of being a facility manager in the sports as well as recreation and facility management. Our activities for Module 13. Hopefully you've read Chapter 16, because there is going to be your quiz. I backed that up to be due at 8 p.m. today on Tuesday. Chapter 16 is titled Legal Responsibilities. You should start sometime studying for the Unit 4 exam. That's Chapters 14 and 15 that we did before Thanksgiving. Chapter 16, which is today's module, Chapter 17 and 18, which is going to be the next module, and the Unit 4 exam will be next week during the last week of classes. You should already be working on your research, and you should have started developing your facility management plan. After this week, you'll have all of the information you need to be able to do, all of the content to complete that signature assignment. It is due next Wednesday, December 6th. That's not something you can do in about an hour. That assignment's going to take you quite a bit of time. It's a challenging, culminating assignment for the whole course that you put everything together. You need to provide yourself about 3 hours to put that all together, and then you need to get away from it and come back and proofread it and go through the rubric at the end to make sure you did everything right. So that might be something you need a couple hours here, a couple hours there, another hour or two to come back and proofread it to get it all together. That's something that we grade really stringently. So make sure you develop yourself a timeline for that and set yourself some time, because that is your culminating activity to see that you've met all the learning objectives for the class. Another thing you should do is look ahead to the module for Thursday, which is going to be posted. It's posted right now. You could get started on it if you wanted. You don't have to wait till Thursday to do it, because it's another virtual plan. You can read Chapter 17, Developing and Implementing a Security Plan, and Chapter 18, Facility Preparation for an Event. In your reading quiz, that's Thursday, November 30th. It's going to be due at 8 p.m. So those are things you'll look ahead to, and then you'll have another virtual lecture that you'll do a journal activity that'll also be due on Thursday, and then there'll be an assignment that'll be due later in the week, and you'll get to go over that when you get to Module 14. What are we going to learn today? Well, by the end of the class, we hope you can do these 4 different Module 13 objectives. So our learning objectives are, we'd like you to be able to discuss, analyze, and apply concepts of various legal issues that affect sports facilities and understand the legal responsibilities of facility managers. All right, and that ties into our course learning objective 1 in the International Facility Management Association principles 1, 2, 3, 4, 5, 6, and 7. We want you to be able to interpret, assess, and apply basic principles of tort and contract law, and we'll teach you what those are, to sport facility operations, and that also ties back to course learning objective 1 and IFMA 3, as well as the last two learning objectives tie into those same learning objectives. We want you to be able to discuss, cite evidence, as well as synthesize how constitutional law and government regulations affect facility management and operations. And we want you to investigate, formulate, and draw conclusions and apply various risk management techniques in order to make facilities safer for employees, participants, and spectators. So as you can see, we want you to take some information. You're going to get some legal terms you're going to have to learn. You're going to have to understand and synthesize some different information on law to be able to then analyze things, consider all that and how it plays into managing a facility. Chapter 16, Legal Responsibilities, gives us all of the background for this lecture. Hopefully you read the chapter. Make sure you take the chapter reading quiz by Tuesday at 8 p.m. and I'll try to fill in the gaps. I'm going to give you a lot of the different terms out of the book and try to explain how some of these things tie into the application of that material into being a facility manager in the real world. So we'll introduce chapter 16 and talk about some legal issues. First thing we have to understand is law. Law is somewhat abstract concept. It's not just getting a speeding ticket or having to go to court, but it's designed to provide guidance and direction for not only just individuals, but societies, organizations, and businesses. If we don't have some kind of law or guidelines, there could be anarchy. So it provides some kind of structure. So law is kind of, like I said, it's abstract, but it provides us with structure. We have to think about, there's laws, there's guidelines, there's all kinds of different things out there. That's what some professional responsibilities are built on. That's what different cases have made laws. So we'll talk about how laws are made and how they apply as we go. So first of all, statutory laws. Statutory laws, they're developed by legislative bodies, such as the government. So when your congressmen get together and they vote on laws, the House of Representatives and the senators, whether it's at the federal level or the state level, when they bring a idea, a bill, and they vote on it and it gets voted through and then say the governor signs off on it, it becomes a law, that is a statutory law. That's done at the state level, but there are other levels that could be done at the county or the city level. And the state level kind of models what the federal level does too. The House of Representatives and the Senate does the same thing. They put laws through, they bring bills, it turns into a law, and then it gets signed off on by the President of the United States. So that's where federal laws and policies come into effect. These could be things like the OSHA laws, the ADA laws, American with Disability Act, Occupational Safety and Health Administration laws. It could be food and beverage laws, the legal drinking age. It could be different city codes, zoning regulations. It could be health codes. It could even be your tax laws in your area. So those are statutory laws. Legislative bodies such as the government have made these laws. So how do we get taxed Do we buy a facility that's in a certain zone? That's how it applies to us. Can we sell alcohol? Can we have our lights on at a certain time? What decibel can we have our sound on our PA system? What about our parking regulations? There's a lot of different things that those statutory laws affect us as a facility manager or owner when we're doing our job in that realm. Common laws, they're a little bit different. So common laws were developed not by the government per se, by our representatives and senators. They were developed in the court systems. So when a law that was on the books developed originally by the legislative body, and then it goes into action in the court, and somebody sues somebody over something saying, well, this is the law and you broke it and I have some damages, and a judge is going to have to determine who's right and who's wrong based on the application of the law. That's how actions in the court system or common laws are developed. So that's laws that are created by judges, kind of in written opinions on how laws are applied. So that's where we talk about the term precedent, not president, but precedent. It's the application or principles of past cases upon laws that were already in effect. So how do we look at what's happened in the past? How does a judge interpret that to the current situation? Have times changed? When you go up and escalate to different courts, do you take it to a court of appeals? They call that the appellate court, and one court might overturn a previous legal decision. But we look at legal decisions, and the judicial system then applies opinions to statutory laws to actually make common laws, and how these laws are then applied in action. So that might be how we have laws requiring you to provide netting at a event to provide safety, or providing a harness if you have somebody that's doing an event like a bungee jump. And is your harness checked for safety protocol? Does it have such a good tensile strength? Does it fit properly? Do you have somebody that has the certification to run that bungee event? And if you don't, then the legal decision could be in the court that you didn't meet all your responsibilities and you were negligent. So then the judge could award damages for negligence. So that would be in an opinion based on some previous applications of the tort laws and negligence. So we need to talk about legal responsibility and risk management. These are two big terms and things we need to understand as a facility manager. We are going to be legally responsible for everybody that walks through that door. So legally responsibility means we have specific duties that are imposed upon us to care for or provide for other people. So we are liable, we have legal liability for everybody that comes in that facility, for all facility users, whether that are our employees, our staff, people that come in to use the facility, whether they're a user, a spectator, a fan, maybe they're a player, maybe they're an athletic trainer, whatever the case. So we have that responsibility to provide a high standard for everybody that comes in. So our company does, as well as we do in that management position. So that's legal responsibility. So we're going to be held legally responsible as a competent, trained professional. And that goes back to some of your professional standards, and you're going to be trained on those professional standards. Risk management's another term that you need to understand. Risk management means you are trying to do everything you can to take on the highest level of legal responsibility to provide care for other people and reduce you and your company's legal responsibility. So risk management is the process of identifying, assessing, and controlling. And by controlling, you're going to try to reduce mitigate, or eliminate threats to your organization. And that might be threats for a lawsuit that could close down, could take away some of your capital, reduce your earnings, basically even close the doors to your company. So it's a process of identifying, assessing, and controlling threats to your organization. So these risks may stem from a variety of sources. It could be financial uncertainties. You're going to have to make sure you make good financial decisions. You don't bring in events that aren't going to make money. You really research different equipment you're going to buy. You make sure you hire the right people. You take on the ideas of understanding the law. You make sure people are trained to reduce legal liabilities. You take care of the technological issues. We don't get tech that's easy to hack into and lose all of our credit cards information. We have to have good strategic management. We don't want to have errors and have a bad strategy and plan all these things and buy things. We're going to buy all these concessions that are consumables, and we did it in a thing where now we didn't get to have any of our March events because it was so cold outside and all this food went bad because it was a consumable that needed to be used. So that was a strategic error. And then we have to always consider accidents and natural disasters. Do we have insurance as a risk management strategy? So those are some things we have to consider as a facility manager. So let's talk about our risk management and legal responsibilities. So there's a variety of them. We have to have processes and procedures in place, and we have to understand and consider all kinds of things. So there's 3 important steps of risk management. First of all, we have to train ourselves, have some critical thinking skills, and understand the risk of our specific facility, right? So have we worked in a facility like this before? Have we talked to other facility managers? Have we studied up? Have we researched the different risks of our facility? So we have to understand the risk. We have to look at all of our equipment. We have to look at what lawsuits have come up running baseball fields. So we have to understand all of the different risks. We have to complete various analysis to analyze the different risks. So we have to go through the process of identifying them and assessing them. And we have to do that regularly. We have to do different checklists. We have to inspect things. We have to re-inspect. We probably have to bring in some experts to help us do that. And then the process of mitigating, which is trying to reduce the risk, and that's how we control our threats. So step 1, understand the risk. Step 2, continue to analyze the risk. And step 3, try to reduce or mitigate the risk. So the 2 most important legal considerations, if we're going back to legal responsibility, we have to understand contracts, and we'll talk about that and how to negotiate that later on today. And we have to understand torts. So torts are things that we're going to get into in a little bit. That's where we can really get sued for a tort. Contract law and torts. Let's introduce contract law now, and we'll come back and talk some more about contracts later. But contract law involves an official agreement between people. Could be 2 people. It could be businesses, and it could be groups of people. It could be a variety of groups. It could be multiple groups. So it could be a verbal agreement, because all contracts don't have to be written in the state of Missouri or most states. It could be a written contract. It could be even a contract that rolls over, that it was written originally and it has a rollover clause and it's not re-signed. So when someone doesn't follow a contract or an agreement, that's when it becomes a legal issue and contract law comes into effect. That's when we call it a breach of contract. Somebody breached the contract, and then that's when it can go to court and there can be some legal proceedings. When a breach of contract occurs, contract law kicks in and it allows you to take the problem to court. You can sue the other party and you can try to earn damages. And it might not just be, oh, they owed me $10,000 for this. It might be $10,000 that you were going to earn, and then it could be some loss, other losses on top of that. So a tort, let's talk about a tort, T-O-R-T. It's an act or omission. So an omission is a failure to act that leads to injury or harm. You either did something wrong or you should have done something and you didn't do it, and then that led to somebody being injured or harmed, as the case. So here's 4 important things that kind of go along with torts here. A tort is a civil wrong for which courts impose liability and then a penalty. So what is liability? Most of you probably understand this from some business law before, but liability is the state of being responsible for something legally. The court or law says you're responsible for it, you're liable for it. So remember, there has to be some kind of injury or some kind of harm. So injury describes an invasion of any legal right. Right? So you could be injured. You could get your arm hurt, your knee hurt, you twist your ankle, could have a slip and fall. Harm is a little bit different. It describes a loss or detriment, in fact, that an individual suffers. So that could even be psychological, right? It doesn't necessarily have to be that you were physically injured. It could be psychological. So remember, liability is the state of being responsible for something by law. So that's what courts are going to look at. Are you liable for something? And if you are, due to your actions or your fail to act, that becomes a tort, and that could be where you're going to have to pay some damages. We'll look at some additional legal issues you need to understand. Constitutional law deals with the interpretation and implementation of the U.S. Constitution in the workplace. So the one spot that we're going to consider as a facility manager is, the biggest one is rights of individuals in the workplace. That's how the Constitution is basically going to apply to us. The first place is in employment laws. So in employment laws, the U.S. Constitution, there's a lot of different things that comes in, but we need to think of, that's where it applies to mediate the relationship between employers, workers, trade unions, and even the government. So think about it. Workers' rights encompass a large array of human rights, from the right to a decent workplace, the freedom of association, the equal opportunity and protection against discrimination. There are specific rights related to the workplace that include health and safety. That's where OSHA comes in. The workplace, the right to privacy at work, amongst many other things. So a lot of your Bill of Rights actually come in on employment laws. When you apply for a job, there are things that you can and can't ask in the hiring process. The American with Disabilities Act, is another one that you could be discriminated against. So there's a lot of the rights of workers in the workplace that we have to consider when we're talking about. All those go back to constitutional law. So when we look at employment laws, your labor unions, your collective bargaining agreements that we talked about earlier in the class when we went back to our human resources unit, all of the employees' rights in the workplace, your contracts, when you contract with external people like vendors, whether it's security or parking or concessions, or you even have your contracts with trade unions, all those things go to employment laws, and those all stem from constitutional and federal law. Next thing is property law. Property law starts with some different places. It started with federal law, but a lot of times property law goes into state law. So property law governs the various forms of ownership. In real property, that could be land or real estate. You'll hear that called real estate a lot, but real property is something that you really don't move. It's there, it's physical. Or personal property. Personal property or items, those are things that can be transportable. You can pick them up and move them. So those could be your equipment within a facility. So property law is going to govern those things. So property refers to legally protected claims to resources. That could be land, that could be your personal property, and now it even qualifies for the last 40 or 50 years or longer as intellectual property. If you have some kind of business idea If you think of things like a trademark or a slogan, things are trademarked or copywritten. You own different things. They're even if you make a product, you might get a patent on it. So intellectual property also has rights to it. Property can be exchanged through contract law. You can sell it. You can sell rights to it. So property can be exchanged through contract law. So you can make a contract. Somebody can pay you to either use it or to buy it from you. And if property rights are violated, even if you have a contract, if they violate the contract, or if you don't have a contract and somebody violates your property rights, they try to take it or use your property without your permission, the owner can sue that person under tort law to protect their own property. So if somebody comes and uses your facility without renting it, or they take your equipment and use it, or they steal anything from you, that's where tort law comes in, and it falls under the property law section. So Carla Veriel talks to us, she gave a good section in the textbook about management practices for safe sports and entertainment venues. She talks about successful risk management and gives a couple of different good tactics and strategies here. The first is develop practices and policies that are effective. First one is staff training. You need to provide training for all of your staff. And this could be anything from first aid, CPR, AED, running those things, to training people to run different systems, to see risk, to analyze them, to mitigate them immediately, to be on the lookout for things that don't look right, and to immediately take some action when they see something that's not right. To train people to have effective communication with patrons. That could be just to tell them to watch out for something that's not right, to take action to calm patrons down when there's a sticky situation, to take charge in an emergency situation. And then policies and procedures. Were the policies and procedures of your facility designed with safety in mind? If they were the employees trained on them? Do the managers know them, or are they just in a book on a shelf? Were the patrons effectively notified? Are there signs everywhere? Is there some layering? Was the PA announcer giving them out? Were they giving them to them in their packet before they came to town? And if you have these policies and procedures, are they actually followed? Do you follow them, or do you just have them out there? Because if you have them and you don't follow them, then they're really not any good. And then is there documentation and investigations after the fact done to ensure that things were done right and to retrain people if they weren't? Next, do we really follow the standards? Does the management know, and are they trained on the standards? And does the management maintain reasonably safe facilities? Do they inspect things when they're supposed to? Do they take things offline? If there's a heat warning in your facility and you're not supposed to play games on your turf due to safety guidelines at over 104 degrees on the turf, oh man, we can get this tournament done if we go ahead and play it, and it's 105. Do you follow the standards, or do you call the game off and push it back? You have to check and see, do you follow all of those different safety guidelines, even if you might lose a little bit of money? Do you meet and exceed all the industry standards? And that could be for equipment. Are you benchmarking yourself? Are you checking to make sure that you're doing things that's above board, that you're running a quality facility? What about your training? Your training for management as well as all of your other staff, that it needs to filter down. Is everybody prepared for an emergency? Do you run some drills? Even if it's an emergency that doesn't happen or may never happen. Have you run a fire drill? Have you run a tornado drill? Have you run a severe weather threat? Have you run a major altercation like a fight threat? Have you run a flood? Have you run something where your electricity goes out or your POS system goes out? Can you be prepared for every emergency? Do you understand how to handle food and alcohol sales? Does everybody understand how to do that? Who can and can't handle alcohol? Who can and can't sell it? and what the different degrees of alcohol are with mixed drinks, beer, wine, who can bus a table, what temperature does food have to be at, when do you have to throw it out, how long can it sit, things like that. And then handling of the conduct of spectators and patrons. Who's prepared to do that? What happens if somebody gets belligerent? Like you got to worry about your younger people, because you're going to have a lot of times 16, 17, 18-year-olds working for you. You got to be careful that you have people that have the right mentality. If you have somebody that gets hot under the collar too, you have to be careful that they don't get their blood pressure up and get into this situation. So you have to train people to effectively handle the conduct of spectators and make sure that they can handle that task. So we need to dig in a little bit deeper so we can understand tort law. Tort law deals with claims of damage to either a person or their property. So there are two different distinguishments here. We can talk about intentional torts and unintentional torts. An intentional tort is when somebody purposely does it. That includes theft, assault, battery, defamation of character. So somebody does something and they might not have long-term planning, but they did it, and while at least they were in the action, they knew they were doing it. All right, they might not have planned to get in a fight when they did assault and battery, but they could have stopped it when they were doing it. So it's an intentional tort. They knew that they were doing it. All right, an unintentional tort refers to taking something from someone, taking someone or something's value without providing them compensation. And you really may not have realized you were doing it at the time. That wasn't really your intent at all. All right, so there's two different things. We'll talk about nuisance and negligence, and then we're going to dig deeper into negligence on the next slide. So an unintentional tort has two different breakdowns. Nuisance would be, think about back when we were talking about building our facility and we were talking about the NIMBY group, not in my backyard. A lot of times they didn't want it because, oh, you're going to have lights on your facility and there's going to be all these lights up. A lot of times, you know, when you put up a facility, if you're going to play at night, you're going to have lights, you might have noise, your PA system, music. There's going to be traffic coming in and out, the noise from the cars, the lights from the cars, lights from your parking lot. And it might not even be you. It might be, you know, the cars with playing loud music, with, you know, in the evening coming, you know, loud pipes on trucks, all kinds of things. People hanging out after the game, just talking. That noise tends to carry later in the evening. So the lights, noise, and traffic from a facility actually could decrease the value or somebody's personal enjoyment of their property if they are close to your facility. So that does happen. I know this for a fact because where I live pretty close to a parking lot for a entertainment venue, and on big weekends there are cars that come in and out of there at 1 or 2 or 3 in the morning, and it is a bit of a pain in the butt. So negligence is the other breakdown here. Negligence refers to an unintentional physical or mental injury, so it could be physical or psychological, through a failure to act. This is the failure, the omission, in a reasonable and prudent manner. So negligence is a primary unintentional tort claim. It's the biggest one. It's the one that goes to court a lot. It's when somebody doesn't do what they're supposed to do, and especially when you're a professional, you're trained, you kind of have a higher standard of care. Your failure to act as a reasonable and prudent professional, not just a reasonable and prudent person. So we'll talk about negligence and the 4 elements of negligence next. So there are 4 elements of negligence, and you have to have all of them present to win a negligence claim if you're going to sue for negligence. So negligence, once again, is the failure to act with the level of care that a reasonable person would have exercised under similar circumstances. So that's what the law is going to say. And then when you're in a professional situation, they're going to tag that in court that another facility manager or another teacher or another coach or another nurse, they're going to look at you as a professional. So you need to exercise the same judgment that another professional of your training would have done. So there are 4 elements required for negligence, and it's important to understand this, all 4 elements must be present to win a negligence claim, to have a valid negligence claim. If one element's missing, there isn't a valid negligence claim, and when it goes to court, the case ends up getting dismissed. So there has to be all 4 of these present for there to be a negligence claim. So first of all, the first one is duty. The duty is the regular expected steps the facility or the facility manager should have taken. So they're an expected step, expected standard of care that should have been done. So consider what a reasonable person or professional would have done in a similar circumstance. Are all the other facilities in the area doing this? Is it a regular considered duty or regular considered circumstance everywhere else across the country, blanket? No, there's 6 other softball facilities and none of them are doing this. So it's not really considered a duty. Okay, then court case dismissed. So a breach of duty is when duties are not reasonably exercised. Right? A fire at a facility is not necessarily breach of duty. Right? But if not complying with the fire codes, you didn't have a sprinkler system, you didn't have your regular inspections, your fire extinguishers, somebody played with them and blew them all out and you didn't get them refilled or recharged, that led to an injury, that would be breach of duty. Right? So it's when duties are not reasonably exercised, that's when there's a breach of duty. You have a facility, people are going to get injured at a sports facility, and you don't have any of your people trained in first aid and CPR. That's a breach of duty as a facility owner or manager. You didn't care enough to have anybody trained and certified to be able to handle that, and that's an expectation. So number 3 would be proximate cause. Proximate cause means that the breach of duty really appeared to be the direct cause or reason that the injury or damage happened. So this could mean somebody slipped and fell when they were walking down the stairs, right? And the failure of the appropriate cleaning of a spilled drink was the reason that they slipped and fell, right? So if they would have just slipped and fell because they were uncoordinated, that's really not your duty or a breach of duty. But there was a spill and it was there for 10 minutes and some other patrons had mentioned, hey, somebody spilled 3 or 4 sodas on the stairs and it's dangerous, and nobody went and cleaned it up. That's a breach of duty, and that was the cause. Somebody came down the steps, slipped in it. Oh, that puts it all together. Yeah, that they actually slipped in the soda. It wasn't just that they were uncoordinated. So that could be the result of the injury. So proximate cause plays right into that. And then injury or damages means that someone must actually be injured or something must actually be damaged because of the other 3 things. So it can't just be a hypothetical. Well, I could have fell down the stairs because there was a bunch of soda there, but I saw it and I grabbed onto the rail and I didn't. Okay, so there's no real injury, so there's no real damages. So all 4 of these things have to be present for there to be a valid negligence claim. But we have to look at those things. If we have a duty, we need to take care of things because it could lead to injury or damages. Another thing we can do as a facility manager is making sure that people understand the assumption of risk. Because anytime people are at a facility doing recreational things, playing sports, doing fitness activities, there is an inherent risk, and that means there's going to be some kind of risk that they take. So we need to make sure people are aware of their risk and that they take some kind of assumption, which means they assume some of the risk. So anything we can do to get them to assume risk helps us take the risk off of us and let them assume it and take some of the risk to themselves. So assumption of risk means that the plaintiff knew about the risk of using our facility or participating in the activities, and they voluntarily assume that risk, and then whatever happened, whether they were injured or have some kind of damages, that they understood the risk and they assumed the risk themselves. So there are a couple of different things. There's 4 things here we need to understand on the assumption of risk. We can put up some signs to let them know. We can have some waivers that they sign. We can give them information in their packets. All right. So there's some things we can do to help them assume some of the risk and that's one of those risk mitigation strategies. So the primary assumption of risk, that occurs when the plaintiff, the plaintiff's going to be the person that sues you, the person that got injured, if you're going to be, and you're going to be the defendant in the lawsuit if you're the manager or owner. So the plaintiff knows about the particular risk through either words or conduct. You told them, or they already knew it and they've done this activity before, or they might have seen it somewhere, there's a sign. So they accept the risk and they kind of relieve the defendant, you, of your duty of care. A secondary assumption of risk exists when the defendant has a continuing duty of reasonable care to the plaintiff, but the plaintiff knows about the risk and proceeds anyway. So, for example, an employer supplies an employee with a defective piece of equipment. The employee goes, hey, you know what? We don't have the flap on this lawnmower, and some rocks kick up occasionally. You need to go ahead and get this flap. And you go, and you as a manager go, oh, okay. I guess you probably shouldn't mow the lawn. Then I'll go up to the hardware store and get the flap. Just leave the mower over here, and I'll be back after lunch. And they go ahead and mow anyway, and then they get a rock kicks up and hits them in the eye. Well, they proceeded anyway. They knew the equipment was defective, but they did it anyway, and you told them they didn't need to. So that's a secondary assumption of risk. All right. An express assumption of risk is when the plaintiff explicitly accepts the risk, whether it's verbal or written, and they go ahead and do it. They say, yeah, I know. I know the risk. I'm going to do it anyway. And an applied assumption of risk is when the plaintiff's conducts demonstrate they know and they just don't care. They might not have agreed to it, but their conduct demonstrates it. So they've done this over and over. There's an inherent risk that you're going to get injured riding a bull. You're eventually going to get hurt, but they continue to ride in the rodeo. So that's implied, even if they didn't sign the waiver. What is legal immunity? So legal immunity is when a person or entity not being able to be held accountable in court for liability due to special legal status. So that's basically usually a government body or a government employee. So many states have it in their constitution or laws that the state government cannot be sued for negligence. And if they can be, it's usually very limited in scope. So this means that someone that's injured at a public high school, they generally cannot sue the state. They might be able to still sue that specific school district, maybe somebody if they didn't do their job at the school, or the manufacturer of the product, if somebody acted in a negligent manner, or if there was some liability on the product manufacturer's part. But generally the state won't be able to get sued in that part. So the courts, generally being that the court it's going to go to state court, they're going to protect the state government entity for the most part. They may dismiss the lawsuit or only provide very limited judgments or awards to the for damages to the plaintiffs. They're generally not going to bankrupt their own school district or their own government agency. So they'll even if somebody does win a court case against a government organization, it's probably going to be for a limited amount of funds. So generally, the only way the government's held accountable by the courts is if the entity acted in a willfully reckless manner. And like I said, then they're probably only going to be get a judgment for some limited funds, but it's going to have to be proven that it's pretty reckless for that to happen. So many states also have some kind of provision that public employees cannot be sued for negligence. This could be, police officers. It could be anybody acting in administrating some kind of policy for the state. So that tries to give them some protection. It's usually in the form of some limited immunity protection. They don't have immunity from everything, but if they're acting in conjunction with their job duties or the best interest of their organization, they're going to have some kind of immunity protection. So to qualify for immunity protection, an employee must act in a reasonable and professional manner when conducting their required job duties. So they don't get immunity protection for everything, and they still have to be reasonable and professional, but they have to be doing the job duties required for their job at the time that they need to do it. So why is this important as managing a facility? Well, if you're working in Public Works Department, if you're working for Parks and Rec Department, anything to work with, the facility management, preparing for the facility, you might work, we talked about even before, you might work for, the Parks Department, working with the Department of the Forestry, or, you might even work as a security officer. There are all kinds of people that do work for state organizations that are funded through the government that do work in recreation. So understanding some of this legal immunity is important, but it's going to be limited, so you have to understand that and be careful as well. So we'll talk a little bit more about risk management now. So risk management attempts to identify risk and mitigate those risks by either reducing or eliminating them. So the first step is to identify all of the various risks. And to do that, you have to analyze and examine your current operations. This includes a variety of risk assessment strategies, and we'll talk about 3 identification strategies here in a second. So to eliminate and reduce risk, you have to systematically generate new strategies and techniques to reduce potential lawsuits and losses. And to do this, you're going to have to try different approaches, and you're going to have to put those into effect and continue to use these. And we'll talk about those on the next slide. So let's start out with step 1, the identification process. So there's all kinds of different ways you can identify risk. You could identify them by being trained manager, having some experience, understanding your facility and just doing the walking around and seeing what risks are there and either taking care of them yourself, putting somebody else on the task immediately, as like it could be mopping up a spill, fixing a tear in your netting, taking a damaged piece of equipment offline. So those are the easy ones, but some major assessment strategies to identify some other major risk are 3 other ones we'll go into here. So the first one is a BIA, or a business impact analysis. This is an impact analysis you do. You're going to look at all the different areas of your operation. You're going to look at your land, your real estate. You're going to look at your facility. If you have a variety of buildings, you're going to look at all of your different equipment. You're going to look at the different events that you host, and you're going to then take 3 different types of threats. the environmental threats, the human threats, and the technological threats, and you're going to see what different things could happen to all of your different facilities, and you're going to see how well you are prepared for all of these different threats and see what you could do to help mitigate or eliminate some of those risks. So an environmental threat would be anything that could happen in the environment. It could be a thunderstorm, a tornado, a fire, a flood. And then do we have insurance for all of those things? Do we have our fire alarms? Have we had a fire inspection? Are we in a floodplain? Have we checked to make sure that our pipes aren't going to freeze in the winter? Have we checked all of our toilets and things like that? What are some of those different environmental threats? It could be even an animal that comes in and feeds off of our trash. Are we making sure we're securing our trash? So the next one would be human threats. So human threats would be anything that humans could do. Are we locking up things to make sure that things aren't getting stolen? Are we making sure that our humans are trained in our human resources so they do things right? Are we making sure that we have our first aid supplies and AED available? Right? And then the last one would be our technological threats. We make sure we have firewalls and all of our things up to date, and we have good enough encryption that none of our credit card information gets stolen and we don't get hacked, that our POS system is up and that we have backup plans. What kind of technology do we have in place? If we run a tournament, like what happens if the tech goes down? Is there any backup to run our bracketing systems and to be able to contact people? So we're going to run the business impact analysis on those three threats on all of our different systems. We're going to see where our strengths and weaknesses are, and then we're going to do things to reduce those risks. The next identification strategy is a SWOT analysis. And a SWOT analysis is another just analytical tool, and you're going to go through all of your operations again. And SWOT is an acronym for looking for strengths, weaknesses, opportunities, and threats. So your strengths, obviously, you're going to parlay off of them. You're going to look for your weaknesses. You're going to then try to find areas to come over those. Opportunities are generally things that might play off your strengths or weaknesses, but those are opportunities to improve. And then your threats are your big ones. Those are areas you could get sued that are usually huge risk, and you're going to have to try to immediately make some kind of change to your operation. So a SWOT analysis is another one that businesses use, and they're going to use this for a variety of things. It'll help you eliminate and reduce some risk, but it's also used in some planning tools to do some things as well outside of just the risk management portion. And using an external analysis concept, they might use one of these other tools, but they might just come in and look at specific areas. So you might contract an external agency or even an external expert to come in and analyze some of your operations. It might be your whole operation, or it might be a specific point. It could be because they provide specific experience or expertise. It could be just to provide a different viewpoint. Somebody can come in and see something that you don't see because you're there every day. They might see something you miss because you maybe have blinders on. It could be somebody that you just don't have that understanding. Somebody comes in and checks your fire code, maybe the health inspector. You have somebody come do a pre-health inspection that used to be the health inspector or was a health inspector somewhere else. Maybe an expert consultant, a building consultant. I used to have vendors come in whenever I was, I didn't know anything about like how the mechanics for the bleachers worked or different things like that. So I would be like, hey, why don't you come in and look at this? And I would have a couple different companies. Tell me what it would cost to like, show me like what we have here and like what repairs would be, what our preventative maintenance strategy would be, what new ones would cost. And man, they would send people out there because they knew you might want to buy some new ones in the future. So they would give you all your maintenance. I was like, but I need a full report on the maintenance so I can like fully understand this and take it to my district. And I'd have like 3 different companies give me those bids, and those would be free. So I would get basically my external analysis done free from different companies, and then I would compare them. And if they all said the same thing, then it was probably true. If only one of them said, oh, this is damaged and it has to do this, and the other 2 said something else, I knew they were just trying to sell me a product. So there was all kinds of different ways you could do external analysis to help with your identification strategies. So once you've gone through the identification process of risk management to determine some of your risk, you're going to take some concepts and approaches to mitigate those risks. That's the process of eliminating or reducing those risks to avoid potential lawsuits. So we have 5 different strategies to help reduce risk here. I'm going to give you a brief introduction to each of these 5, and then we're going to go through each one on their own slide. Actually, we'll couple a couple of them together. But the first one is the ETC approach. The ETC approach is called this because all the steps end in the letters ETC. Kind of clever. Reflect, deflect, inspect, correct, re-inspect, and then reflect on the process. So it's an approach that goes through all of those things, and that's how you're going to try to mitigate your risk. A layering approach, that's where you use multiple layers to warn people of all of the risk that go on. You might have signs, you might have announcements, you might have them sign waivers, you might have people come around and warn them. So they're going to have all kinds of ways, so you're going to use a variety of ways to help reduce your risk. The other ones kind of go together. They deal with your employees. So you're going to worry about training your employees. You have to have an effective training program. So you're going to look, once you analyze your risk, you need to train your employees. Do you have all of your employees trained on all of your equipment, on how to use all of your different systems, on all of your different policies and procedures for emergency management? And then do you have your employees trained on their own safety, on safety of participants, on safety of patrons? So, and do they understand all these different safety protocols, and then do they follow them? So those two, we'll couple those together. And then the last thing is, once you run your analysis, what are your risks? And if all else fails, you need to have the just in case policy. And that is, you need to purchase your insurance and make sure that your insurance covers all the things that could happen and that your coverage is at the right level. So it's important to have various types of business insurance and facility insurance coverage for the just in case. The ETC approach to risk management, I said everything ends with ETC, starts with the reflection process. So you reflect on why you're even implementing your risk management program. So as a facility manager, why are you doing this? And when you get your team together and you're talking about it, because you would like to get your whole management team or even your whole team involved, is the purpose to really save some money? Do we want to make sure that we lower some costs because we don't want to get sued? Are we trying to possibly reduce our insurance premiums? Because sometimes you can save money because you have a safer facility, you have less lawsuits, they come in. Sometimes your insurance company will run an analysis on you. They'll run their own analysis and they'll be like, oh, this is not very risky. Or is it to run a safer facility because you actually do want people to be safe and you want to maybe make a list and you don't make some kind of list where you win an award, or that is just one of your goals. So why are you really doing this? So you want to reflect on it and then design your risk management program around that to meet those goals of what your risk management program is all about. The next one is you need to deflect. So you need to deflect liability onto others as much as you can. You might eventually deflect things onto the insurance companies, but they're not going to take the liability on unless you've done your part too, because they'll refuse to pay the claim and put that back on you and have people sue you. You might even deflect some of that liability onto the users themselves. And how do we do that? Oh, we do that when we go back through that assumption of risk. We have people sign waivers, we have signs up, we make sure that in their information packet when they come to their tournament that they've signed off, that they understand different things. So we're going to deflect some of that liability onto some other people. We might even deflect that onto a vendor because we purchased this product from them. We're the ones that have them come do the inspections. We pay them to do the inspections, and they are the ones that sign off on it that say it's safe. We detect. So we need to detect or identify all of our potential risk or facility concerns. So we're going to do our analysis. So we might have some of those different analysis by doing our BIA or our SWOT or have an external analysis done. But we want to continue to inspect. We need to set up regular inspections on all of the different things. We need to inspect our facility as well. So we go from detection, which could be our identification, and that kind of blurs in the line of inspection, right? So when we talk about inspection, that could be referring to have someone that is qualified to inspect the facility, the equipment, the policies. So we might be the person that's qualified to check some equipment. We might have some staff that's qualified to do that. Or do we have somebody qualified to walk the field to make sure there isn't holes in it? That doesn't take a whole lot of qualifications. But if we want to have our sprinkler system or our fire extinguishers done, we need to have somebody that has that certification and they're qualified to do that. So we need to have our correct inspections done by people that are qualified, and we need to make sure that we do that in a timely manner. So we need to even have our staff do their inspections. Is the bathroom clean? Is the field ready? Is this? But then we need to have our inspections with qualified inspectors, and we need to keep that timeline up and do that routinely. Once we do our inspections, we need to immediately correct any issues that have any dangerous conditions. Do we need repairs? Do we need to take things offline? Do we need to maybe hold off on using this field? Do we need to, move a treadmill? Do we need to take something out that's got a bad cable? We need to correct any issues. Is that repair? Is it replace? Is it stop use? Anything that has any dangerous condition. And then if we have any project going on, if we have any event, especially where there's a changeover, at the end of the day, maybe the next day, whenever the timeline comes up, we need to re-inspect, especially if there's a big project that's completed or we repaired something. We need to, or there's something that there's kind of some regular wear and tear or damage, or it's one of those things that's known to possibly have some unsafe conditions. We need to re-inspect regularly to make sure it meets safety standards. It's a good idea to have a regular re-inspection schedule for buildings, grounds, equipment. It will include a timeline to consider major events or changeover, and even consider your preventative maintenance schedules that we've talked about before. And then at the end, you always want to reflect. Reflect at the completion of any project or event, after a major incident occurs, or every season or year, to ensure that things are updated regularly. So make sure you reflect, especially like if something happens, if a major incident occurs, reflect on it, meet with the team that handled the situation, talk about how it could be done better, and then see if you need to change any policies. Reflect, make sure that documentation got done. Do we have to turn in documentation to the insurance company? So ensure that things are updated, and then that might be just the immediate change to your risk management approach. So the layering approach is another approach used to help mitigate risk. So we'll give an example on this one. Consider a lawsuit. You have to go to court, you're meeting with your attorney, you're coming up with a strategy. You're the facility manager at a sportsplex, and you're subpoenaed to go to court to defend your facility, as well as even yourself, because you're named in the lawsuit, against a liability claim. A fan was struck by a foul ball while sitting in the stands at the baseball, softball portion of your complex. Think about it for a second, and I know you can see it here, but what ways would you attempt to limit your facility's liability? How could you even warn your fans? So, you sit down with your attorney and you have your meeting, and you explain that your facility applied this layering approach to risk management. That really becomes your legal defense, and the facility's attorney uses it as a defense strategy for the situation. And when you get up on the stand, you're going to explain, hey, these are all the different things we did to help warn the person of the risk, as well as we had the screens up everywhere that we were supposed to, and we met industry standards on doing that as well. So first, we printed a warning label on the back of the ticket. So you had to buy a ticket to get in the park, and there was a warning label on the back of the ticket that said, watch for foul balls, and it had all the different inherent risk that could happen. And there's an example of a warning label over there on the right. So you could print something like that on the back of a ticket. You can have a map, and it could be just on your website or the bulletin board somewhere, or rolling on one of your screens up near the concession stands or your entryway, of possible dangerous areas where foul balls could hit. You could post signs in unprotected area, danger, foul balls, all right, not protected from screens. You could mention unprotected areas. Ticket sellers, hey, watch out for foul balls. If you happen to have ushers, not all facilities have that, or in your coaches meetings, or to players and parents, hey, there's unprotected areas in our park, make sure you watch out for foul balls. It's kind of a common thing at a sportsplex, so it's kind of one of those inherent risks that you're normally warned about. If you have a PA announcer and you have an announcement system, you can make announcements before and during contest. Hey, there are unprotected areas, make sure you keep a heads up. There's always foul balls coming through the park. Pay attention for foul balls when you're sitting in the stands. And then you could have reminders from people when sitting during the game. Hey, keep your heads up for the foul ball. Watch out for, foul balls coming in, especially if a foul ball is coming to an area. People yell, heads up, foul ball. Could ask coaches to yell for that. Security, your umpires, because umpires are always going to be on the field. Yell as soon as it's going to an area. That can be umpire training. Hey, make sure if the foul ball is going somewhere where there's not a screen, yell, foul ball, heads up. So there could be things like that. So that could be your layering approach. Not only do we have screens, even more screens than what's required by industry standards, we send the information out to all the teams, and I know this person was a fan. You could go through all those things, but these are the 6 things that we do to try to help warn fans about the risk of foul balls. We have to think about our employees when we talk about risk management and risk mitigation. So we have to think about training and then our safety protocol. We have to make sure that we effectively train our employees on all kinds of things, and that we make sure we train them on safety, and then we expect and demand that they follow our safety protocols. So, and we also have to consider them because it's one of the most often overlooked things. So employee training improves the facility's overall risk management profile, which means it reduces lawsuits. We need to train all employees in various strategies and responsibilities. So one of the biggest things is all employees are responsible to do anything to help avoid potential disaster or a risk. If there's a spill on the floor, if you call the custodian and they're unavailable to get it, or you don't have a custodian on duty, or they're not there in a minute, or there's a high traffic right now, anybody can do it. It's everyone's responsibility to immediately report it or mop it up. Everybody in your facility, no matter who it is, should be trained. It's a sports facility. There's going to be injuries. It's a fitness facility. There's going to be injuries. Everyone should be trained on basic first aid, CPR, and AED. It's just good, sound strategy. Anyone can save a life. You should train everybody, because you never know when people are going to have to jump in on cash flow management, your point of sale system. People should be trained on customer service techniques and how to work with customers and clients. People should be trained on as much of your equipment as possible. If you're in a fitness center, everybody should know how to at least work the basic equipment, the treadmills, like how to get things going. People should have some at least basic knowledge of all the different chemicals, because people never know when they're going to get in a closet to grab some cleaning agent or whatever, and know some of those basic signs on the chemicals. And then you need to just train all employees in all of your basic emergency management protocol. So those are some important things. Employee safety, that's the most often overlooked but most important aspect of risk management for new facility managers. You'll just think people kind of understand that, but you really need to go through training on people having their own safety. A lot of times at facilities, you're going to have a high turnover rate, and you're just going to bring people in and get them to work, and you're going to be busy and working a lot of hours. You need to make sure you train people, they understand your policies, you immediately correct them when they're not doing it right. You can't overlook those things. And then you have to handle those things. It's really important. So here's a couple important things to kind of consider. Common workplace injuries include things like when people lift things wrong or carry things wrong. They can get injured on the job pretty easily. Maybe they're running to get somewhere, they're not paying attention. They have some repetitive motion injuries, doing something over and over and over, even standing at a concession stand, standing at the same spot. It's important to really get those mats for people to stand on if you're going to do that. Repetitive motion, doing, like I said, the same thing over and over. Slip and fall accidents, those are real high, especially in an area where you have some steps or things get spilled. If there's, policies and procedures should be developed to reduce workplace injuries based on your specific type of facility. So the number one cause of, and these are catastrophic, of employee deaths in the workplace are vehicle accidents. So it could be a lawnmower, a car, any type of vehicle or even construction type equipment when you're doing something like that. And the number two cause of employee deaths, believe it or not, in the workplace is from workplace violence. So you have to make sure that you are working with your employees, and if you've seen any aggression or you have some employees that have some action against each other, you can't just let it go. You have to immediately, as a facility manager, step in and stop it and squash it. And if they're not going to be able to work together, you gotta figure that out. That's really important. So policies and procedures should be developed and training programs implemented that attempt to reduce workplace injuries. And then you need to follow your policies and procedures and continue to train and retrain people. So you can't always stop everything. There's going to be injuries. There's going to be things that happen. Sports, fitness, wellness, they're prone to injuries. So there's going to be things that are going to happen. You need to make sure, as your final risk management strategy, that you have the correct insurance coverage. So insurance is when a company purchases a policy, you're going to give away some of your money as a form of protection against potential future financial losses. So like I said, it's a form of risk management, and you're basically kind of hedging some bets. You're paying because there's a chance you're going to have some kind of loss. So you're paying to avoid that loss in the future. So you've all dealt with car insurance and health insurance and things like that. So here's some various types of business insurance policies. You're going to have your general liability insurance. Somebody gets hurt, they sue you. You want to have that liability insurance. Some businesses take some insurance policies out against losses. If you have some different events, you're going to have some insurance. You don't sell enough tickets, you don't do this, that, the other. Things get, you get a check back on that. You're going to have insurance against injuries. That could go with workers' compensation or injuries of participants. You're going to take some insurance out on that. You'll take your commercial vehicle or autos or equipment insurance out. If that gets wrecked or people get hurt in the wreck of that. Natural disasters, you'll have flood insurance, insurance on your facility if a tornado hits it, anything like that. You're going to have your tech insurance for a data breach. If somebody gets in and steals people's credit card information or your data information. You're going to have insurance against employee malpractice, and it depends on what industry you're in, what that is. If one of your employees has a tort and has liability, or they steal from somebody else, are you going to be responsible for it as a manager or the owner? So you're going to have employee practice insurance. Business interruption, the roof gets blown off. you're in a facility and like a ice storm comes in and you aren't able to have tournaments for a week, you can buy insurance against that. Food and alcohol sales, you're going to need to insure if you're doing that. False advertising. People go out and advertise something that's at your place, especially if you are contracting some events out. You can buy insurance policies against that. You'll have your own property insurance. You'll have business owners insurance. If you have a manager that's there, you might have business management insurance. Say the manager knows everything about it, and they have a management contract, and say they get injured or killed and can't be on the job. There's different management insurance where they will pay somebody that's an expert to come in and run it for you while you get another manager hired. Equipment replacement cost, and then prize and contest management. You know, these places, you've all been somewhere where somebody hits a shot from half court, or they hit the hole in one, or they do whatever and they win $100,000. Well, the company doesn't pay the $100,000. They pay a fee to be able to do that, and it's an insurance that somebody's not going to hit that, and then the company basically, if they do, you know, there's all kinds of different things you have to go in, and you know, how many participants are there going to be, and there can't be this, this, and this, but they pay out the prize. Actually, the facility generally doesn't. I told you earlier we'd get to contracts, so let's talk about contracts a little bit, and we'll talk about negotiating contracts and some property law and things. Contracts and the 4 elements for a valid contract are important here. So a contract, once again, is a legally binding agreement that defines and governs the rights and duties between the parties or among the parties that enter into that contract. So contracts don't have to be in writing to be legal or effective. Every state has some differences in that. Some do, need to be in writing. Depends on like the length of the contract, the amount of the contract, what the contract's for. Some of them do have to be in writing to be legal, but it depends on your state. So a real estate or anything that requires more than a year to complete should be in writing. It just depends, like I said, state by state. So an important concern for all contracts is you have to keep them current. So you have to see when the start date and the end date on the contract is. You have to make sure that people meet deadlines, or if they don't meet a deadline, does the contract expire? Does it change? Is there some kind of escalation clause? Does it change the way that the contract is paid out? Does the price change? So there's usually some kind of expiration date. The price has changed. Does a contract roll over, or is it voided? At the end of a contract, does it auto roll over? Does it auto renew if somebody doesn't sign off of it or get out of it? Or if you don't do it by a certain time, 90 days by the end of the contract, is it done? So you got to look at how those things are to keep contracts current. So there's 4 important elements required for a valid contract. There has to be an actual official offer of a contract and an official acceptance. So you offer someone $1,000 to paint the offices in your facility. If they don't say yes, it's not a valid contract. Or if somebody says, I'm going to paint your offices for $1,000, and they just come in and start painting it, and you never said, yeah, okay, I'm good with that, you don't have to pay them $1,000. So there has to be an offer and an acceptance on both sides. The next thing is there needs to be some kind of consideration. The consideration means there needs to be an exchange of something for a contract to be valid. Like I have to give you either money, there needs to be a monetary payment, or we're going to have some kind of trade. Hey, right, I'm going to paint the offices in your facility, but you're going to let my team then use this and not charge us rent for 100 hours of our workouts or our practices. So we're going to trade out. We're going to trade. That's our consideration. So it doesn't always have to be a money trade, a money payment. It can always be some kind of trade. So there needs to be capacity. Capacity is required. So capacity means people must have the ability to enter into a contract. So some states require you to be 18, or it depends on sometimes you can be 16 with a parent's consent, or if it's under so many dollars. You might have to have a certain mental status or mental state, right? So you might not be able to have somebody that has a lower IQ or is, has a lower mental ability. They have to have the mental capacity to be able to enter into a contract. Or if they're under duress, they're under the influence of drugs and alcohol, they're really stressed out and like about ready to, lose it. So they have to have the mental capacity and emotional capacity, as well as the legal age capacity to be able to, say yes and enter into a contract. If they're under coercion from somebody else, somebody's there and they're like, you're going to have to do this, and then they really didn't want to, they don't really have the capacity either to enter into the contract. So the last one is legality. So contracts must be legal to enforce. A court would not intervene in a contract and make it valid and say, oh, you have to pay that person the $1 million for that illegal narcotic, because that wasn't a legal contract. So there has to be legality too. An important skill for anybody is the ability to negotiate, but to be in business or to be a facility manager, you have to understand how to negotiate contracts. One of the first things you need to do is always try to give somebody to give you the offer first, so then you can make a counter offer. Like if somebody's going to offer you a job, or you want to buy a car or buy a house, if there's already not a price there or a original offer, you want them to give it to you first, because you don't want to overstate or undersell or whatever the case. You want them to give it to you so then you can see if it was where you thought it was, or make some kind of counteroffer. You always want them to give you the original. So the ability to negotiate various contracts is a really important skill and ability for a facility manager to develop and be able to effectively apply or use as a business strategy on the job. You're going to do all kinds of contracts. It might just be a contract with a vendor on who we're going to buy soap from, or it could be a contract on if we're going to sell the naming rights to the building, or our pouring rights to our concession stand, or maybe just selling some advertising. Or it might be somebody's coming in and, hey, can I get a family discount on some tickets? So you're going to negotiate all kinds of contracts over time. So here are some important considerations when negotiating contracts. If it's not a contract you want and it's not the best deal for you, find an alternative or walk away. You can find another contract. So this can be, an important strategy. A lot of times you can come back to that contract. So avoid unfair escalation clauses. So an unfair escalation clause means if something doesn't occur at this time, and that timeline might be tough for you, that the price goes up or interest gets charged, or you lose the ability to do whatever. So don't get yourself in some kind of unfair situation where things get escalated or the contract gets voided and then they can rewrite you a whole new contract. So say you're renting a facility and payments due by this time, and it escalates to this in 30 days, and if not, contract gets voided. Well, you've already moved all your stuff in. You could really be out a lot of money to try to move your facility. So avoid the unfair ones. Yes, it might be fair for you to have to pay a late fee, but avoid unfair ones. Obtain the right to audit the books. If you're going to purchase a company or take on something, obtain the right to really look at everything. Like if you're bringing in an event and they said, oh, we've run these different events at different places and we've made revenue, and they kind of show you a little bit of a balance sheet, you want there to be everything. Like it's critical to see everything, like the whole income sheet, the whole previous information. You want to see what's been collected here, especially if there's going to be some kind of revenue split or calculation of expenses for the contract. You're going to want to be able to audit their previous stuff, and you're going to want to have the right to audit the event right then, what the real ticket sales were. Avoid changing the base year of any type of contract. A base year is the first year in the series of years of some kind of financial index. It's typically set to like an arbitrary level. This is like the 100, so it's 100%. So if we're trying to change things over time where it's like, oh, the first year is 100 and the next year you're going to pay 110%, don't let them, like, after so long, change the base year so then that percentage goes up. So be careful of that. Companies will try to sneak that one in on you. Consider holdover charges. So if you're the tenant, limit the charges for staying several days over the initial lease ending date. If you have events booked in your facility, you might want to consider higher holdover charges to people if they, if you have to cancel some events or move events, or you can't get your clients back in there because they haven't moved their stuff out. You might want to have higher holdover charges, but try to have, if you're the person that has to get out, try to see if you can get lower holdover charges, or maybe get a couple days without holdover charges. So consider how those impact you as either the facility owner or the person that's coming in and using the facility. Consider all the implications for revenue sharing. If you're the tenant, you got to be careful on that. How are things divided? What methods will be used for calculation? How's the payment going to be made? Can you audit the books? Can you check everything before somebody leaves if it's your facility? What happens if there's not revenue? Like, so somebody comes in and runs an event in your facility and they try to show a loss, but they used your facility and you're going to show a loss. Like, do they have to pay anything out to you? Like, what are all those different implications? Detail who was contracting and paying various vendors, union workers, how payroll, overtime, and bonuses are all going to be handled. All that needs to be handled if that's going to be some kind of event strategy. Who's paying parking, who's doing all these different things, who's able to collect different things. If you run your own concession stand, and are they going to try to put a food truck out there? Like, there's got to be all kinds of different details in your contract up front, depending on what you're doing. And then understand all your contract riders, especially if you have events coming in or touring performers. So what's a contract rider? Touring performers are really difficult with some of this sometimes, especially if you look at like musical artists or people that kind of or think that they're not think, but they are stars. Like, they would write really goofy things in their contract riders just because they wanted it that way. So the band Van Halen, Eddie Van Halen just passed away recently. That was the guitarist. They went through several different lead singers, but he wanted M&Ms in his changing room, but they couldn't have any brown M&Ms in there. So you would have to get somebody to get M&Ms and pick out all the brown M&Ms. And if that wasn't carefully followed in the contract, he got like 200 extra tickets at no cost, and you lost the revenue on those tickets. So that was crazy. So some performers requested certain numbers of tickets in certain areas. They wanted certain foods or certain comforts. Madonna wanted a new toilet seat installed in the performer's dressing room before she got there, because she didn't want to sit on a toilet seat that anybody else had sat on. So there are all kinds of different contract riders, and you have to be careful, like, can you actually make that work? How much is that going to cost you? Is it worth it? So you have to look at some of those different things when you run a facility. So constitutional law defines the roles, powers, and structures of various government branches or entities. So there's 3 branches of government: the executive branch, the legislative branch, and the judicial branch. So the executive branch, it's the one that carries out the laws. At the federal level, that's the White House. It's the president. At the state level, right, that's the governor's office, right? So like I say, they're the ones that carry out the laws. We consider that the administrative area. If we want to look at the legislative branch, at the federal and state level, that could be the Senate and House of Representatives at the federal level, and it's also the state senators and state representatives at the state level. They are the ones that make the laws. They bring bills in, they vote on them, they're the ones that send them to the governor or the president that signs off on them to turn them into law. So they vote on them, basically make the law and send them to the president. The president can sign off on them and the president then executes them. And then the last one is the judicial branch. The judicial branch is the court systems. So there are various court systems at the federal and state levels. There's the court systems that you might have to go to determine if you broke a law. There might be appeals courts. There might be courts that actually hear legal cases to determine if laws are constitutional or not. So they evaluate laws and evaluate people, evaluate and interpret laws and evaluate people's actions according to the law. So let's talk about applying constitutional law to athletic and sports facilities. It doesn't always apply, but it applies in a variety of situations. Constitutional law may not always directly apply to managing private facilities, but a lot of facilities do take some public funding, so it has more application there. And it does always apply in human resources and human resource management situations. So First Amendment rights, that's a big application. It includes freedom of religion, free exercise of religion, freedom of speech, freedom of assembly. There are all kinds of different rights there. This applies to our employment processes and our approach, especially with human resource management. How we determine to hire people, do we discriminate against people in the hiring process and the termination process, and who gets to use our facility. So First Amendment rights do apply to a variety of facilities. So we need to consider those in how we manage facilities. The 14th Amendment protections address citizenship rights, equal protection under the law for everyone in the facility. So if we think about our civil rights, think about citizenship. Like, can we fairly discriminate against somebody because of an race or gender or what nationality they identify against or with? So everybody deserves equal protection under the law. So we have to consider the 14th Amendment protections with, once again, our staffing considerations as well as people that use our facility. And when people use our facility, how are we going to protect those users, if we have users that disagree with things? Like, we have to protect users against users with their First Amendment and their civil rights. So when we consider the 14th Amendment, we have to think about the Equal Protection Clause. It mandates that individuals in similar situations be treated equally by the law. So let's take a case here. When we want to apply constitutional law to a facility, let's talk about a sports facility, say a baseball stadium. There's a professional baseball game going on. The game's over. It's a Major League Baseball game and it's in Yankee Stadium. And there's reporters that want to come in to the locker room afterwards, and guys are still coming in and out of the shower. And a female reporter wants to come in, and they get held out, and she says, well, this is discrimination due to gender. I should have the same right and should be treated equally under the law to be able to get in, and I can't do my job because I'm a female. and the locker room attendant in security says, no, it's because guys are still showering. Like, that's kind of inappropriate, right? Said, well, then everybody should be held out. The males shouldn't be in until everybody's done showering. Or you should just have people come out to a press conference. So there was a lawsuit that was brought against the Yankees. And believe it or not, the Yankees lost this legal battle. And one of the things that was cited from the judge that heard this was that her rights, due to the Equal Protection Clause and the 14th Amendment protections, her rights were violated, but it applied to constitutional law because the Yankees used public funding to build their stadium, so therefore they couldn't say it was a private facility in any way. So that was one of the points that was used against the Yankees in making that decision. So besides constitutional law, there are a variety of other government regulations we need to understand as a facility manager. And those go back to some risk management as well. We need to understand them and understand how to apply them to make sure that we're doing our job and not getting sued, not breaking the law. A lot of these we've talked about along the way. But some government regulations include understanding taxes, the taxing rate. If we're in a city, is there additional taxes there? Are we taking out employment taxes when we're paying our employees? Are we doing the unemployment tax? Are we paying all of those different things correctly? Are we following the building codes if we're building a facility? We need to understand those. We talked a little bit about that in the past. Do we understand our zoning regulations? We talked about that in urban planning before. And then all of our safety regulations, and that's going to be somewhat in building, but then how we go on and manage and open and continue to run the facility. Are we going to handle all those safety regulations? And that's in, facility management and our concession stand and our food service and everything we do from there on out. So regulations or laws may be imposed on our facilities based on perceived needs or uncertainties in new technologies or even a recent tragedy that happened. So that's how laws come about. That's how the senators and representatives, they hear it from their constituents, or that's how the judges end up making case law because things get sued because of this. So government regulations include legislation that's passed to possibly improve safety. And here's a couple of examples. In 2000, Minnesota passed a law called the Uniform Building Code, and most states have a Uniform Building Code, and so do cities and counties. And it's different place to place. But in Minnesota, they added a new one for new rules to improve bleacher safety due to a variety of accidents in different high schools due to bleacher malfunctions. In Connecticut, this was in 2013, so a decade ago, they adopted new rules for swimming pool safety. And this was after 2 high school students died during swimming class. So these were both in direct reaction to recent tragedy that led to some perceived needs that led to some new laws or government regulations. The Occupational Safety and Health Act, known as OSHA. You've heard of OSHA regulations. There's posters hanging up. You've probably worked somewhere where you've heard of OSHA before. It's a federal law. And this federal law was really designed to help employees. It was designed to ensure that employers provided employees with an environment free from regular recognized hazards in the workplace. So this could be anything from exposure to chemicals that could be toxic, excessive noise levels that could make you go hard of hearing or lose your hearing over life, mechanical dangers that could cause you to get injured on the job, excessive heat or cold stress, or even unsanitary conditions, extremely long work hours, repetitive injury conditions. So all kinds of things to help make the workplace safer for you as an employee. And then you're usually going to have an accountant help you with this, or you need to have some kind of basic financial literacy and understanding. But tax regulations, they include a lot of different things. You're going to pay income tax, but you need to make sure that if you're not getting just a contracted employee where you're getting it all and then you have to pay it yourself, that your employer takes out income taxes correctly for employees. You have to understand the sales tax and sales tax rate, ticket-related surcharges, how that works. Are there property taxes? Is there city tax? Is there a specific entertainment tax? Do you have to collect taxes from traveling entertainment while they're there? Like, places come in, like if you have traveling entertainment or professional actors, do you have to take their tax out for your state? Because if they take off, they may not pay it and you might get charged for it. So we need to consider the American with Disabilities Act and how we need to be in compliance with ADA as a facility. And as a facility manager, some of the things we need to do. So the ADA, the American with Disability Act, prohibits discrimination based on any type of disabling condition. It requires facilities, it's a federal law, by the way, it requires facilities to provide equal access to employment opportunities and requires facilities to make reasonable accommodations for individuals with any type of disability. It requires facilities to provide equal opportunities for use for individuals with disabilities through 3 different areas. First of all, by removal of architectural barriers. So this is by having steps and different things such as really, really long walkways from public parking, small restrooms. So some of the ways you can remove some of those architectural barriers is by providing public accommodations. Can you change one or multiple restrooms into handicap accessible restrooms? Can you make some handicap accessible parking closer to your fields? Can you make, or closer to your entryway? Can you possibly provide, a golf cart or a cart to help people in and out? Can you provide a ramp or a cutout in the curb or an elevator or escalator? Can you make 1 or 2 of your 6 to 8 fields handicap accessible and then rotate where people need them? So that's providing public accommodations. So it's sometimes the removal of barriers and providing of accommodations go hand in hand. And then improving options for people with disabilities, especially the hearing or visually impaired. So what kind of options can you add for those people in the workplace? Can you have bigger screens? Can you provide different telephones, the telephones that have screens on them that read things out? Is there some technology you can use for them in the workplace, or some accommodations to help them use your facility like Braille, larger signs, different things like that? So there are all kinds of different options to help with that. So you need to understand the term reasonable accommodations too. So reasonable accommodations for a small facility doesn't mean you correct everything. It means you try to correct both architectural and some program related barriers to use as readily achievable means as you can. So can you make some repairs or modifications without significant difficulty or exorbitant costs to your operation? It doesn't mean you have to make every restroom handicap accessible. Can you make maybe 1 stall in each one handicap accessible? Can you put in a couple of parking spots, or like I said, make possibly 1 field handicap accessible? You may not be able to put an elevator in, but if you have something upstairs, can you provide access to what's upstairs downstairs to people? If you have a concession stand upstairs, can you have a remote ordering area downstairs and have people bring the items downstairs to people? So it includes some different things, And we need to remember that this also includes providing equitable participation opportunities too. A smaller facility and one that's older, you have to try to make corrections, and it depends on your use and different things and your numbers, but you have to try to make reasonable accommodations. You don't have to make all of them. So facility managers can show you're attempting to make reasonable accommodations by reducing or eliminating your discriminatory practices or discriminatory architectural or program-related barriers, by completing a continuous review and modification process of your facilities, your policies, your practices, and procedures to improve or be in as much compliance with ADA as possible. So that's really important to do, and have that continuous process to be in compliance and to continue to make reasonable accommodations. So we'll go ahead and wrap up Module 13, a summary of legal considerations. So remember, laws, they're designed to provide guidance and directions for individuals, businesses, societies, so we don't have anarchy. They're just kind of a framework of things there, but once laws go into effect, we kind of have to follow them, or there's going to be some kind of consequence. What is risk management? It's the process of identifying, assessing, and then trying to minimize threats to an organization, a lot of times to their capital, their holdings, or their earnings. The two most important legal considerations that we talked about, they're contract considerations and torts. A tort, remember, that's a civil wrong for which courts impose liability, and when liability, you get charged with that or found guilty of causing a libelous injury, like negligence, you're probably going to have to pay some kind of legal damages. What is negligence? Negligence refers to, it could be unintentional or even intentional, physical or psychological injury or harm through a failure to act in a reasonable and prudent manner. So the top legal concern for a tort case for a facility manager is negligence. A contract. A contract's a legally binding agreement that defines and governs the rights and duties between or among its parties. It can be in writing. It doesn't necessarily have to be. You've got to check your state laws on that. Remember, there's 4 different elements of a contract. There has to be an offer and acceptance. That's element 1. There has to be some kind of consideration. There has to be something traded, whether it's money or some kind of services. There has to be capacity. People have to be of legal age and not under duress, and mental capacity. And then it has to be legal. You have to be doing legal goods in a legal trade. And then government regulations, those are important for a facility manager to understand. They might include taxes, building codes, zoning, variety of regulations, safety regulations, ADA, OSHA, and constitutional laws. So that'll help us wrap up legal considerations. So let's get to our assignment for this module. It's a discussion assignment. So we'll have an initial posting and then our 2 responses or follow-ups to classmates. It'll be an actual article review as well. So we're going to discuss legal issues. So start by completing some internet research to find and select an article with adequate information on a legal issue that a sports, recreation, or fitness and wellness facility has faced in the past 10 years. So I mean adequate information by, it needs to have enough information to provide a couple of detailed paragraphs. It needs to be probably a 2 or 3 page article or more so you can read through it. It doesn't need to be a 20-page article or anything like that. It could be a review of a court case about something we talked about today, torts, negligence, whatever the case. It could be like an injury, but it can't just be like a little blurb, like half a page or something. It needs to have quite a bit of information so you can write a review of it. So here's some legal issues to consider. You could talk about torts, negligence, constitutional law violations, common law violations, or judgments awarded against a facility by a court. You can think of you can use anything that was covered in this chapter or in the module today, any of those topics. Here's an example, and you can't use this example, so don't use this example, but here's an example. A legal judgment where somebody got a monetary award to a fan struck by a foul ball at a sports facility that didn't have adequate netting. So you could find an article on something like that and then write the review, and the review is going to be these next 6 points on that. So don't use that example, but frame your mind around that. It could be any other thing that's a legal issue. It could be on contract law, it could be on anything. It could be constitutional law, common law violations, torts, negligence, somebody got hurt in a facility, whatever the case. All right, so your initial discussion posting questions, and the first 3 are pretty simple. I want you to provide the title of the article you'll review, and it needs to be somewhat current in the last 10 years. Provide the source of the article. So where did you get it? Was it a journal, a newspaper article? Was it from a website? Was it a court report? Was it by an author? Just give me the source there so I kind of know where it came from. Was it a review of a news source? You know, sometimes they'll write a review of like a TV news source. Provide the hyperlink to the article so we can get the article. I can look at the article and everybody else can. And then you're going to write 3 detailed paragraphs. So all that first stuff was just getting us the information of the article. So in one detailed paragraph, and remember a detailed paragraph is 4 or more sentences, don't short it. Provide detailed description and discussion of what the major legal issue or issues from the article were. So tell us what it's about and explain it. So kind of detail the article a little bit. You can provide more than 4 sentences. In at least a detailed paragraph, fully detail the outcome or findings. Was there a settlement? Was there some kind of judgment? Settlement was the plaintiff said, oh, we're going to lose here. We're just going to give you $500,000 and this is why. Was there a judgment? That means the judge awarded somebody this amount of money and they usually cite why they awarded it. Or did they create a new law, like that new bleacher law got enacted that I told you earlier in the presentation. And number 6, in a detailed paragraph, explain how you'll use this knowledge from this case and the findings and a little bit about risk management in the professional career field of being a facility manager in the future. So just kind of reading through the article, what you might have thought. So the discussion assignment deadlines, Wednesday, November 29th, have your initial posting up. And then by Friday, December 1st, 8 p.m., have your 2 responses to classmates. Remember, the Wednesday shows up on the to-do list and Friday doesn't. Some of you guys still forget this, so set yourself a reminder for the Friday. So here's our to-do list. Module 13 assignments, your to-do list, your chapter 13, or I'm sorry. So here's your assignments. So Module 13 has a to-do list and Module 14 has a look-ahead list. So for Module 13 on your to-do list, start out with these 2. Chapter 16 reading quiz on legal responsibilities. It's due Tuesday, November 28th at 8 p.m. Should have read that hopefully already, and if not, you can read it after you've done this presentation. Journal activity for Module 13. Hopefully you did that along with the presentation. That is just taking your active notes on the different terms and questions that I've provided you information with at the beginning of the show. Put that in Canvas. It's called Journal Activity Module 13. It's on Chapter 16. It's due Tuesday, November 28th at 8 p.m. And then your discussion on legal issues. The initial posting is Wednesday, November 29th at 8 p.m. and your 2 responses to classmates, Friday, December 1st at 8 p.m. Don't forget to put a reminder in and do that follow-up on Friday. So your Module 14 assignments, your look ahead. Make sure, and this is posted, so you can go ahead and get started on it as of Monday if you would like. You don't have to wait until Thursday to do it. Read Chapter 17, Developing and Implementing a Security Plan, and Chapter 18, Facility Preparation for an Event. There's a reading quiz that's due Thursday, November 30th at 8 p.m. That's both of those chapters combined into one reading quiz. You will also have a journal activity for Module 14 that'll be due Thursday, also at 8 p.m. And that is when you go through, just like this one, take active notes. And then you'll have an assignment that you'll see in that presentation. It's not a discussion, it's just a straight assignment that'll be due over the weekend. So here's your information for Module 14. I know I just gave you a look ahead list, but Thursday, November 30th, there's no class meeting. We have another virtual presentation lecture. So Module 14 is Event and Security Management. It's posted in Canvas. The whole thing is up and ready to go as of Monday. Read Chapter 17, Developing and Implementing a Security Plan. Read Chapter 18, Facility Preparation for an Event. Read and listen to the virtual presentation. It replaces a class on Thursday since we have no class meeting. It's posted in Canvas. There's a link in the Module 14 information page, and I'm going to attempt to go ahead and put just a file link in there as well under the link for the day. The reading quiz for Chapter 17 and 18, it's combined into one reading quiz. It's due Thursday, November 30th at 8. Your journal activity, which is your active note-taking for Module 14, is due Thursday, November 30th at 8 p.m. It's up and active, so you could start on it now if you'd like. And your assignment, Event Preparation Considerations, it's up and active as well. It's due Sunday, December 3rd at 8 p.m. So both modules for this week are up and available, and you can get started on them early if you'd like. Here's a look ahead to Modules 15 and 16. So we had virtual on Module 13 and 14, but Module 15 we will be back at our regular class meeting time for face-to-face meetings. I will not be there, but you will have a proctor assist you. So here's what you need to do. Study and complete the Unit 4 exam. That's in Module 16, and it's due Monday, December 4th. Make sure you plan your transportation for your facility tour to Helias Catholic High School. That's meeting at regular class time. You can either meet Coach O Tuesday, December 5th in the concourse area there in Jason Gym in the entryway and leave with him at regular class time, follow him over to Helias, or you can meet at Helias High School at the front entryway. And then there will be an assignment for a facility review after that. You might want to look at that assignment prior to going, or you should look at that assignment on Monday prior to going to the facility tour. It's posted in Canvas. Make sure you're working on your facility management plan. That is in Module 16. It is due on Wednesday, December 6th. Plan your transportation for your facility tour. You might want to talk to your classmates on Tuesday if you don't have a vehicle, but it's at the Special Olympics TFL Training for Life facility, a little bit southwest of town on 54. It's about 9 minutes away. Information on that is up in Module 15. It's Thursday, December 7th. There will not be a ride from myself or Coach O there, so you need to be able to get there on your own or with a classmate. So talk to your classmates and please work that out. The tour will start at 2:35, so I give you 10 minutes to get out there from our normal class start time. And that as well, look at it on Wednesday at the latest at your facility review so you know what you're looking for when you're out there. And the facility review will be due after your tour. And then read your course portfolio, just glance through that, and your course post-test, which will be open a week early, is due Tuesday, December 12th, but you can take that plenty early. Actually, it'll be open on Monday, December 4th, so you can take it anytime before that, and it's just a carbon copy of the pre-test. Make sure you analyze your score once I go in and grade the fill in the blank questions and provide your final score and compare it to your pre-test and see how well you did and how much you improved over the semester. So that's your look ahead to modules 15 and 16. Make sure you're working on that facility management plan. Just wanted to give you the information on the Unit 4 exam. The material for the exam, everything on chapters 14, 15 that we did before Thanksgiving, and 16, 17, and 18 that we did when we came back from break. So material from any of those chapters will be on this exam. It's probably about evenly divided between the chapters. The deadline for the exam is Monday, December 4th at 8 p.m. So make sure you get the exam done by then. It'll close out. It opens on Thursday before that. So here's your information. There's 42 questions. There's 90-minute time limit. There's going to be several. It's like most of our normal tests. There's some selected response where you get to pick multiple choice or true and false. And there's some constructed response where you'll have to do some fill in the blanks. The information's either from the textbook reading or from our lectures. There's some test safeguards. Once you put in an answer, you can't backtrack and change it. All your questions and answers are randomized. There's that 90-minute time limit. So you need to study prior to taking the test, because if not, you'll end up running out of time. Study like an in-class test. Study before you open it. Make sure you prepare. Take your notes. Limit, the best you can on these last couple chapters. Read over them before you take the test. Limit your distractions. Get to an area free of distractions. Get your phone away from you so it's not ringing and you're texting somebody else and you're on your social media. Your textbook and documents and lectures are all included on this. You can use them as resources, but you can't phone a friend. That's an individual assignment. Try to make sure you get on very good internet, because once you start the clock, it starts rolling. So if you can get on wired in and get on a device instead of your phone, you'll have better luck. Hey, good luck on the exam. Sorry I'm not there right now, and look forward to seeing you next semester. And we will have the other virtual lecture up for you for Thursday.